It's a pleasure to be here. My first degree was a science degree in pure maths and computing, straight after school. I was the archetypal migrant kid from the north of England. Parents came out here, got a better education and opportunity than I ever would have in my hometown, and did well out of it, but sort of opted for the technical profession, and then for a variety of reasons ended up going back to university in the mid-80s and studying a Bachelor of Economics, majoring in government, and that was a great time to study economics and politics during the early years of the Hawke government. At the end of that, I was hunting around for a job, trying to figure out what to do, and I was back writing computer code because I was quite good at that and it paid well. And I saw a job in the Australian for a 6-month contract for researcher at the ABC to work on the 1990 federal election. Had to have knowledge of electoral systems and elections, knowledge of computers, background in media, something else. I had everything else except the media. But I applied. I thought, great fun. I can do that. And I was, at the time, looking for a job as a trainee economist, and I thought I could always go back to economics. So 150 people applied for the job, and they interviewed 8, 3 with PhDs, and they picked me. And I think one of the main reasons was my bubbling, sparkling enthusiasm. But secondly, the computer background, which at the time was quite rare, and I think they thought I could talk to the computer people. So I worked on that and did a book of notes, and at the end of election night in 1990, which went to about 1:30 in the morning, Andrew Olley and Paul Lynham and Kerry O'Brien all told the head of News and Current Affairs, you should re-employ that bloke, he knows what he's doing. And so they did, and they gave me the job of redesigning their computer system to do election nights, which I did, and we still basically use the same system today. It does all those accurate predictions, which no one else has, so I designed all that. Still a great telling point. We were doing a discussion today for the planning of the election coverage, and we were talking about the bottom of frame where the numbers of seats won by each party is displayed, and one of the graphic artists was saying, it's a bit boring, it's the same numbers all the night, and I said, yeah, but they're miles ahead of anybody else, so we're quite happy to stick with them. But they also stuck me on camera one day and they decided it made sense, and it just went from there, so quite an unusual occupation. But as a result, I've got a mix of professions and skills, mathematical background, strong background in history, a smattering of constitutional law, especially in the area of conventions, which is where most politics tends to occur rather than the actual hard law. It's actually the conventions surrounding the law, which is often more important in politics, although Gough Whitlam didn't understand that in 1975. So, on to this publication, which has got some interesting papers. Now, I'm told none of the authors are here, so I don't have to apologise for mispronouncing any names because I haven't had a chance to check them. But I'm going to particularly talk in a while on the savings provisions aspects of the paper on savings provisions, which I find most interesting. But I'll touch briefly on some of the other papers. Alexander Riley and I think it's Tiziana Teresi on voting rights of permanent residents. Second section of the paper started with a paragraph, very few nations currently grant voting rights to non-citizens in national elections. So you knew they were in a tough case when they say that at the very beginning. But I must say, as a migrant kid who came as a 4-year-old, and when I started to vote in 1978, I was not a citizen and I had the right to vote. And after 1984, when they stopped non-citizens getting on the electoral roll, I continued to have that right because I had been on the roll in 84, and there are still Australians today who are not citizens who still have that right. So it is more interesting to have that argument on the basis of how citizenship has changed over the years. And there are many papers which aren't legal papers on that issue of the changing perceptions of citizenship in this country. And what you need to look at is things like changing flags, changing national anthems. I had to swear allegiance to the Queen, which people no longer have to do. So these things do change over time, and as George Williams and others will talk about, Hill versus Sue, or whatever the case was, where the High Court finally accepted that the British Crown and the Australian Crown were different, and one couldn't have allegiance to both at the same time. A very important case, but one that people don't really understand sometimes what emotionally that meant as well as constitutionally. I think Elisa Arcioni, the core of the Australian Constitution, the people and the electors, I thought that was wonderful for reminding me of a section of Section 128 of the Constitution which I'd forgotten about entirely, because it's one of those until the Parliament otherwise provides sections, so you tend to skip over it. And there it is in paragraph 4, about putting forward a constitution. And then it says, but until the qualifications of electors of members of the House of Representatives becomes uniform throughout the Commonwealth, only one half of electors voting for and against the proposed law shall be counted in any state in which adult suffrage prevails. Now, I must have read that at some point in my life and then not really understood the relevance of it until this paper pointed out to me this was because women had the vote in South Australia, and everyone was very concerned that South Australian votes therefore carried twice the weight of the rest of the country. I don't think Edmund Barton's reputation would be as good if people knew his response, which is included in this paper, that perhaps the section should include a section only the votes of men should be counted. And he also, in the same section paper, makes some comments about the narrow interpretation of the word he in reference to elected members of Parliament. He was one of the only members of the convention who thought he meant male, which was interesting to see that. The paper was interesting for that point, for reminding me that these issues in relation to women voting in 1901 was very relevant in terms of what's the definition of the people. And some others have done very detailed papers on how many Indigenous Australians in some states lost the right to vote in 1902 because of the changes to laws. And in fact, that section wasn't used to protect their rights. The relevant section, I think it's 41, wasn't used to protect their rights at the time. Graham Moore and Ron Levy do a paper on regulating opinion polls, to which my thought was, are they trying to actually stop newspapers having the only exclusive they still have? It is interesting, having worked on Australian elections, we have no rules on when results can be reported in this country. In Canada, for a number of years, for a decade, they tried to hold back the world, and they stopped any results from the eastern states being reported until polling closed in British Columbia. In the age of the internet and Facebook and Twitter, this was becoming increasingly untenable, and the recent Canadian election finally abolished that ban. The American networks do not have a similar ban, but the networks themselves have their own rules on that, on reporting results on election night. Because all elections in America are held on the same day, calling the American election too early in the eastern states has a significant impact on turnout on all other elections in California. If people think the president's already been determined, they may not turn out to vote. And that has an impact on the California Congress, the Californian governor, the referendums, local government, dog catchers, the mayor, all those other elections which are held on the same day. So the convention is they do not call the elections too early. And of course, the famous case of 2000, when they called the election too early and they were wrong, has proved that case ever since. So in 2012, when I was asked to do election coverage for the ABC, for the American election, I'd had the odd experience of being in New Zealand watching Barack Obama claim victory. Don't ask me why. I think it was a New Zealand election. Straight after Obama's speech, I had to go give commentary on a debate between Helen Clark and John Key. And I think my first comment was, I thought the rhetoric of the debate was less overpowering than what we heard earlier, and it certainly was. But anyway, no one would call Obama won when he'd won Ohio and Pennsylvania, which was clear, but nobody would call it. So when I was asked to do a coverage here, I remember sitting down with the head of news and sort of saying, well, I'll do it if we can give away the decided states on the polls. Can you do that? I said, yeah. We're in Australia. Nobody's watching from America. We can do what we like. So we called all the safe states early. So we gave California to Obama in 2012 at the start of the coverage. What was the point of hanging around for 3 hours and we knew who'd won? So right at the start, we gave away the states, and so for 3 hours, we had seat numbers at the bottom of the ABC screen, which were miles ahead of the American networks. Much more. We weren't doing anything new. When they gave away a state in the close states, we gave it away about 30 seconds later, because we just did it. And so we didn't call it before anybody else. And in fact, because Ohio was the key state, you couldn't call it till Ohio came in. We just did it. But I mean, it was an interesting experiment to look at how people think you can or can't do something. In Australia, we have no rules, and never have. We've always broadcast results into Western Australia ahead of time. Some people many years ago thought that was odd. Again, in the age of Facebook and Twitter, how would you ever stop that occurring? You could take the Canadian example of stagger the hours, but it's too difficult to do. Paul Kadir and Rodney Smith, Kildea, has done a paper on the challenges of informed voting at constitutional referendums. To me, that is quite fascinating because Queensland just had a referendum on fixed 4-year terms. And nobody thought it had a hope of getting up. Who was going to vote the Queensland Parliament to have another 4 years and fixed? Have 4 years and fixed, given the government had nearly fallen over the week before when someone left the government, given that people hated Campbell Newman when he left office, they hated Anna Bligh when she left office. Why would they go and vote for fixed 4-year terms? Anyway, the government put up two cases, a yes case and a no case. Neither of them are particularly exciting. The yes case sort of said everybody who supported it. It's got broad support, the workers support it, business supports it, tourism, local government, seniors, and gives a couple of basic arguments. The no case set out the cases which were pretty obvious, Queenslanders will have to wait longer to vote out bad governments. It's the wrong for a state with no upper house. Increased social cost puts politicians' job security ahead of voters' rights. Who supports it? The ALP government, the LNP opposition, politicians. Why? So, it's just wonderful stuff. And then Professor Graham Orr was quoted as saying, "It is naive to think that just by changing to 4-year terms, you are going to improve the culture of executive government." The people voted 53% yes. It just astonished everybody. An incredibly low-key referendum, and the public voted yes. Does this mean perhaps that we shouldn't have informed debates? We should just hold the referendums and not tell anyone about it? It does raise that interesting question. Of course, referendums at the federal level have been more political in that sense. Not since 1977 have we had referendums with bipartisan support. This referendum had bipartisan support. A similar referendum in New South Wales in 1995 on fixed 4-year terms also passed with bipartisan support. But, having said all those things, and that quote from Graham Orr and the problems of the upper house, what should happen 2 weeks later? But the government had a bill put forward by the opposition to add 4 seats to the House of to the Legislative Assembly. A reasonable measure. The government didn't like it because the seats probably wouldn't be in areas where the Labor Party would do well. They would go in growth areas where the LNP does well. So they were opposed to it. But the crossbench, the government not having a majority, backed it. And so the government, the opposition, with the help of the crossbenchers and some defecting Labor members, now independents on the crossbench, thought they would move this bill and give it urgency, which they did, and they moved it. And it got through the first reading and the second reading and into the committee stage, at which point, snap, the government moved an amendment to abolish optional preferential voting. Fundamental change to the way people fill in their ballot papers, the way the ballot papers are counted. 18 minutes notice, they moved this amendment. They'd already keyed it up with the crossbenchers. The bill's in committee. They've got the numbers. It goes through the committee to the third reading. The opposition has no choice at this stage, having lined up the crossbenchers, but to back the bill that came out of committee. So with no warning, no prior consultation, no discussion with anybody. A principle that had been in place in Queensland since 1992 as a follow-on from the Fitzgerald Commission was just abolished between 4 o'clock and 7 o'clock in the afternoon with no warning. Truly an astonishing thing to do, and something that could only happen in Queensland was what everybody warned about 3 weeks earlier with a referendum. So I thought it was appalling, and I've had people coming onto my blog sort of saying, "Oh, it's all right for governments to do that." No, it's not. These are the same people who criticised Campbell Newman for all sorts of things. When he introduced changes to have ID laws, he actually put it out for submissions. They ignored the submissions and paid no attention to anybody, but they went through a process. This was not a process. This was like, right, guys, we're doing this, bang, whack, through. And that's what happened. So the next election in Queensland will have to number all the squares, which is where he comes to the final paper in this issue, which is by Narelle Marigliotta and Zim Nkwara, I think it's pronounced. They've done an issue on the issue of savings provisions. Savings provisions, and it's very relevant at the moment, coming up with Senate reform, are what you do with ballot papers to allow as many ballot papers to count as possible. We have very complex methods of counting in this country, of voting in this country. Most people in the world turn up, with the exception of the Americans, where they've got dozens and dozens of elections on the same day. They turn up and they one mark on a ballot paper, and that's all they do. It may be proportional representation, it may be first past the post, but the overwhelming majority of people in the world make one mark, usually a cross. That's all they have to do. In Australia, we make people turn up to vote for a start, and then we make them fill in all the squares, and then we present them with ballot papers like this. This, for those of you who aren't old enough, is the 1999 New South Wales Upper House ballot paper, the famous tablecloth. It has 264 candidates and 81 columns. Now, thankfully, it's if you look at the top here, it's above and below the line voting, but they triple-decked it. So if you can understand why there are these 3 lines with lots of names and stuff like that and all this down there. Now, to conduct this election, there were so many laws broken. They had to hire bigger aeroplanes to fly the ballot papers across the state. Heavier paper, What else did they do? The glue on the postal vote envelopes wasn't strong enough to hold them closed with this ballot paper folded up. So all these postal votes were arriving open, having flipped open. People putting in pre-poll votes, they had to widen the slots on all the boxes so you could get the paper in, which meant you could put your hand in and pull ballot papers out. I mean, it was like, there was so many things wrong. And then they when they counted them, it was all done at a centre in Pyrmont. Take a look at it. And in the middle of the count, New South Wales was hit by one of the worst hailstorms in our history. And all the above-the-line votes were all sealed up in plastic in this room at the back where the roof collapsed. An asbestos roof. So to access all those ballot papers for the continuing account, they had to go in moon suits to go and pick through the remains of the asbestos ceiling. But anyway, they eventually won it, and it's a remarkable result. That was the first case of preference harvesting. Glenn Drury, who we all know as the preference whisperer nowadays, organised at least 20 of the parties on that ballot paper. And there were some great parties. There's the Marijuana Smokers' Rights Party, which is one of the ones he already got 2%. It did quite well. And then there was the Gay and Lesbian Party, which apparently had no gay and lesbian members. It was a bunch of four-wheel drive activists. And there was a bunch of gay rights activists who'd organised a party called Stop Banks Exploiting Australians. So there was all sorts of things going on with that system. So anyway, let's just pass over that as a mad little occurrence. So that's where lots of people got this idea about stuff. But this is also why you need savings provisions. And where's my lower house ballot papers gone? They're here somewhere. Just lost them. Doesn't matter. When you fill in here we are. When you fill in a ballot paper in this country, you have to fill in all the squares. That's a lower house ballot paper. I think it's a Benelong in 1998. You must number all the squares 1 to 13. It's got I forgot about this. There's a gentleman on this ballot paper called Prime Minister John Pissed the Family Court and Legal Aid. There's a party called Abolish Child Support Family Court Party. They all changed their name by deed poll. One of them changed his name to John, the family court won't let me see my children. Anyway, they changed the law after to stop people having false names. And unfortunately, there was a Brisbane drag queen called Tamara Tonight who promptly found she couldn't run for Parliament anymore. But such are the joys of names. Anyway, you must number 1 to 13 on this ballot paper. And if you make an error, too bad. Your error it's wrong. And to solve that, there are two types of general provisions in the Electoral Act. One is a broad provision that a ballot paper should remain formal as long as the voter's intent is clear. That's not much use in a system like that, because the only ballot paper that gets saved by that is if the last square is blank, where it's presumed to be the last number, or where there is confusion over the numbers between 1 and 7. People who cross the number and use the European-style numbering. There's confusion over the numbering, and it's now been ruled that you must look at the whole entirety of the ballot paper, not just the two numbers, the whole sequence. So there's a number of very small provisions. What's more interesting is optional preferential voting as applies in New South Wales, where you only have to fill in one square and everything else is beyond that is optional. And the case I'll raise there is what happened in that sort of law. In 1980, we introduced optional preferential voting in New South Wales, and the Rand government entrenched in the Constitution. It can only be repealed by referendum, which is another interesting bit of constitutional law in this country that you can insert things in constitutions and then entrench them in various ways. But optional preferential voting is entrenched. An election or two later, there was a dispute at a close election on whether ticks and crosses should be allowed, and the court ruled that the voter's intent was clear. There are criminal cases in this country all year round, fraud cases, where the intent of a mark on a form has to be imputed by the court. What was the intent of the vote? What was the intent of the mark on this social security form? So there is lots of law on intent of marks on paper, and that has been translated into electoral law under optional preferential voting. If you use a single tick or a single cross and there's no other mark on the ballot paper, that can be imputed to be a 1. What happened in 1991, in a somewhat disgraceful situation, the Greiner government decided to hold a referendum. It passed, and I'll just read this out because it's a great bit of referendum. Do you approve of it? It was going to cut the size of the Legislative Council and shorten the terms and elect half the council every 4 years instead of 1/3. Do you approve of a bill to reduce the number of politicians in the Legislative Council and to reduce their maximum term of office. Yes! To apply the Legislative Council the same rules for filling casual vacancies as the Senate. I mean, the wording of the question about reducing the number of politicians was why that referendum passed with 57% support, despite Labor opposition. But before that election, they changed the formality rules, these savings provisions, and they specifically excluded ticks and crosses at that election. So that if you used a tick or a cross on your ballot paper, it was informal. It had been formal for the previous 3 by this implication, but they deliberately ruled it out. That referendum was held the same day with a ballot paper which had 2 boxes, yes and no, and the instructions were to cross one of the boxes. But if you used that cross on the other ballot paper, it was informal. And in the 4 electorates where there were only 2 candidates, the informal rate shot up to 25% in one of them. The rate of informal voting at that election in New South Wales was tripled to 9.3%, as high as 25 and 30% in parts of Bankstown and Penrith, where people, given a ballot paper with 2 boxes saying use an X, and another ballot paper where it said use a 1, they used an X again, and it was informal because they'd changed the formality rules. That shows why these sorts of rules are important. We are imputing what the intent is, but that's all we have. An election is people have filled in a ballot paper. We know who they voted for. Can we imply from it? Optional preferential voting gives you lots of rules about how to do that. Which brings me on to the current Senate changes that are occurring. What happened with the Senate ballot paper, and I'll get that prop. This is the New South Wales ballot paper from the last federal election. It's not as big as that. It's only got 110 candidates. But under federal electoral law, they can't triple deck or double deck. They have to appear on a single line. So the only option was to make the print size smaller. And because the print size was made smaller, they issued magnifying glasses. So you could read that. So you could sit with your 1 metre ballot paper in your 600 millimetre polling state with your magnifying glass and your pencil and try and figure out to vote 1 above the line or 1 to 110 below. Understandably, 98% of people voted 1 above the line, including 9.5% who voted for David Leyonhjelm and the Liberal Democrats in column A, clearly not having understood that was not the Liberals and Nationals, who were about 2/3 the way along the ballot paper. I think it is a thundering disgrace to conduct an election in these circumstances where people need a magnifying glass to vote on such a ridiculous ballot paper, which they can't read. You needed the dexterity of a contortionist to vote, the eyesight of a hawk, and the manual skills of an origami artist. So something had to be done, and the proposal has been to get rid of the ticket voting system. There will still be above and below the line voting. You only have to vote 1 to 6 above, and you can vote 1 to 12 below. But for me, the sticking point in all the discussions, which is the New South Wales system since 2003, the sticking point in this was, what do you do about people who've just voted 1? That was the original proposal from the Joint Standing Committee on Electoral Matters. It was broadened because there was concern there would be too many exhausted preferences, and the quota was 14.3%, unlike 4.5% in New South Wales. So they wanted people to fill in more squares, which is where this idea of 1 to 6, and when I first started to discuss this with the Greens and Nick Xenophon, I said, you have to have a savings provision. What's a savings provision? A savings provision is something that allows you to say this ballot paper has not been filled in according to the instructions, but we believe its intent is still clear enough and the motive of the person filling in the ballot paper is still strong enough that we'll count that ballot paper. In this country, because of full preferential voting, we have a lot of rules explaining why you can't count a ballot paper and not enough explaining why you can. We had the Bradfield by-election in 2009, which had 22 candidates, including 9 Christian Democrats. The Liberal Party got 56% of the vote. There were 73,000 ballot papers, and all 73,000 were checked for a sequence of 1 to 22 being correctly filled in. Now, the Liberal candidate got 56%. Not one preference needed to be counted in that election, but they still checked all 73,000 ballot papers for a sequence of 1 to 22, despite the fact none of those preferences were required. So in other words, we've got rules which define what can't count rather than what can count. My prime motive in the Senate reforms was to ensure that people's intents could still count. And for 30 years in this country, people had just voted 1 in the Senate. And oddly enough, people don't read legislation very often. They don't always read the instructions on their ballot papers. Talk to anybody who works in retail as to whether people read the instructions when they're taking a new television or computer or electrical appliance home. They don't. They think they know how it runs. They plugs it in, it blows up, and then they wonder what's wrong. It's the same with voting. They presume that most politicians aren't going to do something stupid which will deprive them of their vote. So a significant number, 15 to 20%, might turn up and just vote one. So you've got to have a savings provision for that, and I kept hammering that, and everybody agreed, and that was what was in the final bill, that if the instructions say you must vote at least 1 to 6, if you only vote 1 or you vote 1, 2, or you make an error and go 1, 2, 2, it will still count because it's got a valid first preference, and those preferences will now only apply to that ticket. If you want the system has abolished any party control over preferences. It's now entirely under the control of any party control. It's now entirely under the control of the voters. Outside of a party ticket, the only preferences that count are the ones filled in by voters, and I consider that's an improvement that we'll find out next week in the High Court whether that stands up to challenge. And my view is it will stand up easily, and certainly if the ticket system in the new system is ruled invalid by the High Court, it's impossible to see how the existing ticket voting system could remain valid. So that was put up, and that will ensure there isn't a huge surge in informal vote. Anyone who's turned up and voted above the line of the current system will still have a formal vote under the new system. Because in fact, back in 1984 when the current system was introduced, the argument was over optional versus full preferential voting, because we had 9.5% informal vote from 1922 to 1983, and nobody seems to have quite agreed that it was caused by compulsory preferential voting and maybe you should do something about it. But it took 60 years before somebody tried to do something about it. Nobody would accept optional preferential voting, so they invented ticket voting. What's happening now is we're going back to the debate about optional versus full preferential voting. I then had the strange situation where the government had retained this idea of you must number all the squares below the line. And I sort of went through a whole bunch of logic about why this was a problem and why this would get the High Court sniffing around the edges. Because if you voted 1 to 6 above the line, and an individual group could have up to 2 candidates, then that corresponded to 12 candidates below the line. But if you voted for those same candidates 1 to 12 below the line, it was going to be informal. More importantly, if you wanted to put those 12 candidates in a different order than the tickets, it was going to be informal. You would have to number all the squares. And I said I didn't think there was a constitutional problem, but the High Court would be asking some very rude questions about what was this formality about. I had Matthias Coleman on the phone. Can I talk to you? You're very important. And we went backwards and forwards. And about the following Monday, I started getting this phone call with thinking of making it 1 to 12 below the line. Yes, I thought. And then he said, what do you think we should have as a savings provision? And savings provisions are funny things. And I looked at what was instructions, and I said, well, how about 1 to 6 below the line is okay? Because if someone reads the ballot paper, it says vote 1 to 6 above. And if someone reads that and goes 1 to 6 below, it will be informal. So that's what was written into the Act. You must vote 1 to 6, even though it says 1 to 12. Again, there's also some conspiracies. People think this is all there so that people can do a Just Vote 1 campaign. No. The parties aren't interested in a Just Vote 1 campaign for the Senate. They're handing out how-to-vote cards for lower houses, and they don't want anyone thinking a Just Vote 1 is okay in the House, because that's informal. But then people start saying, well, we should be publicising the savings provisions, and my view is the intent of the Act is they want people to give preferences, and that's what they are saying on the ballot paper, and I think that's what should be encouraged, and I'll continue to argue that. But you don't write the savings provisions on the ballot paper. The current savings provision, if you vote below the line, is you only have to fill in 90% of the squares, and you must make no more than 3 sequencing errors. You couldn't put that on a ballot paper. Nobody understands what it means. In fact, most of the scrutineers don't know what it means. They use a computer program to check. But there are still some peculiarities in our system. If you vote 1, 2, 3, 99, or 100 on a ballot paper, it's informal because you've broken the sequence. I think it's pretty damn clear what the voter intended on that ballot paper, but it's informal. I'd love to see more of these rules checked, and these are sorts of things that can be written into the Act and the paper that Narelle and Zim put out. They point to some of these issues, but they're looking at it in a more generic way. I've pointed out a couple of scandals like the New South Wales 91 election where these things have some relevance, which is why these laws are important. There was a letter in the, and I'll finish with this point, there was a letter in the Australian several weeks ago criticising the Electoral Commission for allowing the Senate ballot papers to get as unreadable and unwieldy as this, and for not ruling out parties which were clearly fronts. Well, in law, how do you define a front party? You try and write a law which defines a party as a front for somebody else. How do you do it? So, the Electoral Commission can't reject a party for being a front because there's no such thing in the Act anyway. And as for the shape of the ballot paper, well, that's in the Act. The Electoral Commission is not responsible for the Act. The politicians are responsible for the Act. So I keep getting interviews with outraged electoral radio people sort of saying, why doesn't the Electoral Commission do something about this? Well, it can't. I mean, we had great fun. Who's the WikiLeaks bloke? Julian Assange. I don't know anybody who can figure out how he could lodge an enrolment form at the last election. He's lived overseas for years. He's off the electoral roll. How does he get back on the electoral roll? Well, there's a simple reason. The Electoral Commission can't refuse it if he claims that he is. If he swears that he is entitled, it's not for the Electoral Commission to question it. So it takes it. If after the election he were elected, then you could take it to the High Court and rule that he wasn't on the electoral roll and therefore he shouldn't have been a candidate. And there were all sorts of funny constitutional cases that flowed from that. But outraged people saying, why did the Electoral Commission allow that? Well, simple, that's what the law says. And that's where some of these journal articles are very important, for pointing out some of the fairly obvious points, that electoral elections rely on law, and there are things that electoral commissions can't do, and it's because the law doesn't allow them to. And if people want to make complaints about the law, the people that should be complaining to is politicians, not the Electoral Commission, and it's a very key point people make. So I'll end there. I think there's some useful articles here, and I think it's good that Zim and Narelle have done this article, because I know I spoke to them when they were doing an earlier draft of this, and there's lots of interesting things in this area, the inconsistencies between different states. Congratulations on the journal. It's quite a doorstopper. Congratulations on the sub-editing. I do tables of, I do publications with lots of numbers, and I write databases to ensure that I don't have to type numbers as much as possible, because I know how difficult it is, can actually verify. And I did a publication recently, and everything I'd typed said automatically was correct. And the only thing I'd done by hand, which was a by-election, had an error. So I can well understand how difficult it is. And as for all those footnotes, well done to actually get it out together. So I think it's my job to launch this. Just say congratulations and welcome to volume 39.1 of the University of New South Wales Law Journal, and congratulations. Thank you.